Under what circumstances can the New York City Police Department and the City of New York be held liable for a person's murder? To find out, you have to read Howell versus City of New York. It's only 66 pages. Don't have time for that? I got you covered. TLDR, too long didn't read, Court of Appeals in 5 minutes or less. The case of Howell versus City of New York. This is a long, complicated case. I'm going to try and get this done in 5 minutes or less. It can be found at 2022 New York Slip Opinion 06633, published November 22nd, 2022. This is a civil case in which Dora Howell sued the NYPD and the City of New York for the police department's failure to protect her from her ex-boyfriend, who consistently violated the order of protection that she had against him. And they didn't arrest him. They didn't arrest the ex-boyfriend like the law required them to do. She sues, and the question is, can a domestic violence victim in this kind of circumstance sue a police department for their failures to stop the third party from violating and hurting the injured party? And the majority's answer is no, they cannot. The facts of this case are very long and complex, but to break it down simply, Dora Howell was the victim over a long period of time of violence from her intimate partner, her ex-boyfriend. She got 8 orders of protection ultimately. She kept calling the police. They didn't arrest the defendant. They just basically kept telling him to leave, or they tell her to stop calling. Ultimately, he threw her out of a third-story window, and she was paralyzed, and she sued. And there was there were several discovery conferences and depositions ordered. The police never showed up for any of their ordered depositions. And ultimately, the police department in the city make a motion for summary judgment saying, Judge, dispose of this case without a trial because the plaintiff can't sustain their burden of proof. The trial judge denied that. The appellate division, when it gets to them, grants it, and it goes to the Court of Appeals, and they basically say the appellate division was right to grant the summary judgment, disposing of the case without a trial. They go through the fact that if you sue a municipality for negligence, you have to prove a special duty. There's 3 tests for special duty they go through: the statutory test, the special relationship test, and the affirmative control of a known dangerous condition test. Under the statutory test, they say if the plaintiff belongs to a class identified by a statute, and number 2, recognition of a private right of action where they could sue for a violation of their rights would promote the legislative intent, and number 3, a private right of action would be consistent with the legislative scheme of the statute, then you can sue under the statutory special duty theory. Number 2, if there's a special relationship test, special relationship between the municipality or its agents and the injured party can sue. And that's a 4-part test. Number 1, was there an assumption by the municipality, either in words or action, to protect the injured party? Number 2, was there knowledge by the municipality or its agents that inaction could harm the injured party? Number 3, was there direct contact between the municipality's agents and the injured party? And number 4, did the injured party justifiably rely upon the municipality and its agents to protect the injured party? If all 4 of those are present and established, then you can sue in a private right of action a municipality or an agency like the NYPD under the theory of special relationship. And number 3 is the affirmative control of a known dangerous condition. Like if a municipality buys a toxic dump, then they know that this could result in harm. The majority goes through each of these tests and says, no. There's no way that Dora Howell could make out any of these. And they specifically say that she can't establish a justifiable reliance upon the NYPD. And also that there's no statutory protection granted by the issuance of an order of protection. Goes to the dissent of Judge Wilson. Judge Wilson disagrees completely and goes through even more of the history and explains that every single one of those theories that would allow Dora Howell to sue the municipality and the police department in negligence, each of them could arguably be made out. And it shouldn't be disposed of on a summary judgment. It should go to the jury. Let the jury decide if there's a statutory duty. Let the jury decide if there's a affirmative control of a known dangerous condition. Let the jury decide if there's a tribal issue of fact as to whether or not they established justifiable reliance. So that's Judge Wilson. And finally, there's Judge Wilson would hold that the issuance of domestic violence order of protection establishes the duty. by the Domestic Violence Intervention Act of 1994. And finally, there's Judge Rivera, who goes to the history as well and says that the fact that the police have no discretion, but they have to arrest a violator in order of protection establishes the duty here as well. She would agree that Dora Howell should be able to proceed in her lawsuit. 5 minutes or less. Dora Howell versus New York City and the Police Department. If you like what you just saw and you want more of it, please hit like or subscribe to let me know.